Okay, welcome everyone again. I heard we are the first roundtable. Unfortunately, we are right before the lunch, so we have to be very time efficient. And especially following Professor Scheffer's opening remark, I think we have to continue the momentum and even deliver better content, right? In order to compensate your hunger for food and for knowledge, of course, right? Okay, let me quickly use the opening, my time to introduce our distinguished speaker today. On my left-hand side, this is Ms. Van Damme, Isabelle Van Damme. She is now a doctoral professor at World Trade Institute, University of Bern. Oh, your name is right there. Okay. She's been practicing, writing, teaching international economic law, and at a very early stage, I think she has worked with John Jackson on WTO law. That's a long time ago, but you look so young. And later, she finished her doctoral dissertation on treaty interpretation of by the appellate body, WTO. So we're very fortunate to have Isabelle here. Let me go lady first. So Mōri Shimizu, she's worked for a long time for Japanese government in the Ministry of Economic Affairs, Trade, and Industry. So her specialty is on WTO FTA rules. And later, she's been working on dispute settlement, including WTO dispute settlement, as well as arbitration and ADR. She also has her focus on energy and natural resources. She's now a professor in University of Osaka, as well as she's of counsel for Anderson, Mōri, and Tomotsune. And the gentleman there is Nicholas. Nicholas is now working for Foxconn, the famous multinational corporation from Taiwan. I've known Nicholas for a long time, Mr. Liao, Nicholas Liao. She went to the United States not only to study, but also work for the United States government, EPA, for some time, and practice there too. Okay, that's a quick introduction. For this, I would say, very important but very vast topic, we would like to focus on 4 issues. So let me give you a roadmap. In the first part, we will discuss the overall context of trade and investment for semiconductors as of today. The second part, we are going to discuss the changing regulations, the moving targets as related to semiconductors and how corporations are responding to it. The third part, we will touch around the trade and investment under international law, okay? So naturally, there will be WTO, FTA, BIT, and soft law, okay? So that's the third part. For the last part, we will discuss national security, a form of arbitrariness, as Professor Scheffer has told us, and the other geopolitical uncertainties. So I saved this to the last because, otherwise it will occupy the whole session, the uncertainty. And then, of course, we will try to save some time for Q&A. So now let's begin the first topic for the overall context of the current trade investment for semiconductors. And Isabelle will give us some factual background, especially when semiconductor is such an important strategic asset, right?
Thank you so much for that kind introduction and leading this roundtable discussion. So I think when we talk about semiconductors, we're talking about really foundational technology. As you mentioned, strategic assets, and increasingly access to these assets is being limited and control over these assets is being imposed. that is done often now for national interest and sometimes also then specifically for national security interests. Semiconductors is not really a singular group of products. They often talk about semiconductors as a type of ecosystem. So it, of course, covers trade in semiconductors, but also in related goods, in raw materials, in manufacturing equipment. It's about technology, it's about know-how, and it's about technology transfers. So I think that for these reasons, it's quite useful to start this conference this morning with a roundtable on trade in semiconductors, because it really sets the stage for many of the issues that we'll be discussing during the next 3 days when it comes to trade and investment. Of course, talking about semiconductors in Taipei has a particular meaning and there's a specific context. But I think that even if the conference had not been taking place in Taipei, that we would still be starting this conference with talking about semiconductors. And let me just give you a few examples of the various tensions that we see when talking about semiconductors. And these tensions will come up in other conversations during the next 3 days. So talking about semiconductors, we're of course talking about industrial policy and the interest of many countries to bring production of semiconductors or part of the supply chain at home. That in turn is then linked with subsidies and potentially also the issue of foreign subsidies, whether we look at the US CHIPS Act, the EU CHIPS Act, China's big fund, etc. So we have industrial policy and subsidies. Second, we have export control, or third, even this is the third point. And we see increasingly export controls being imposed or becoming stricter. And these export controls can potentially affect each phase of the production of semiconductors. So it can affect research and development, design, manufacturing, assembly, testing, packaging, as well as distribution. And export control has often been used or seen as a trade policy instrument where we understood it had to it's about military items, it's about dual use, where you put some burden on trade in civil use goods in order to capture and control the trade on the military use of those particular goods. But I think we need to wonder when thinking about export control on semiconductors if we don't see an overall repurposing of export control as a tool. A fourth issue relating to semiconductors is the question also of sanctions, and we'll have several panels on the issue of sanctions. So some countries, as part of their sanctions policy, are imposing sanctions related specifically to the issue of semiconductors. And then you have other countries that impose sanctions for other reasons, consider, for example, the Russia sanctions, and then in those sanctions there are restrictions on raw materials, manufacturing equipment, etc., relevant to semiconductors. These four factors already indicate that we are dealing here probably with a very complicated supply chain. And that even gets more complicated because when we're talking about semiconductors, it is a deeply globalized and interdependent supply chain. So it's illustrative of some of the supply chain struggles we're seeing also in other sectors. To illustrate this, we see that a lot of the design is still in the hands of the US. Manufacturing, of course, happens very much here in Taiwan, in South Korea. Assembly happens a lot in many different Southeast Asian countries. Many of the key raw materials, for example, are sourced from Japan. And then you have countries like the Netherlands that have some kind of really advantage in a particular type of manufacturing equipment. So very complex interdependent supply chains, which means, of course, that these supply chains are also very vulnerable. That brings in risks relating to climate change. We have the pandemic that showed some of these supply chain shocks, and that is only in addition to all of the geopolitical tensions that arise. And those are independent reasons also for countries to look at diversifying the sources of production. And let me just add a few more issues that arise in respect of trade in semiconductors, and that we'll discuss during the next few days. It's a deep concern about the issue of technology transfers in respect of semiconductors, especially insofar as dual-use goods. In general, we see that concerns are being more and more raised about technology transfers, and there is an interest of certain countries in having many more checks on research and development collaboration and also much more restrictive licensing. when talking about bringing production at home, and we see a lot of countries are trying to attract a lot of foreign direct investment, at the same time also the obstacles for foreign direct investments are becoming more visible under the disguise of FDI screening. And these issues are all coupled. And then we see also kind of broader topics coming up in terms of trade in semiconductors, namely the interaction between WTO law and free trade agreements in terms of their potential for liberalization, but also their potential of protecting policy space for countries. There's the issue of soft law that is important, and soft law cooperation, whether we're dealing with export control or then also specifically more and more forms of soft law cooperation in respect of semiconductors. And then, of course, there are all the autonomous or sometimes called unilateral measures that are being taken. And then finally, just maybe to kind of justify including this topic so early on in our conference, is that, of course, semiconductor diplomacy must also be seen as a form of conflict management in respect of certain geopolitical tensions. And that is also becoming much more important in respect of the discussions we'll have during the next 3 days. Thank you.
Thank you, Isabelle. That's a very quick overall big picture of what we are doing now. One disclaimer I didn't mention is that something we cannot give you today is how to buy or sell semiconductor stocks. But we can give you how you see semiconductor long-term in the context of international economic law. How is that? Okay, right. So next we will go to Mōri. Mōri, because she has been working with Japanese government, so she knows how Japan sees semiconductor industry, right?
Thank you so much. It's my great honor to be in this panel and in front of all distinguished colleagues. Thank you again for Isabelle for that great overview of the current context. And I would like to make an excuse that I was in Minister of Economy, Trade and Industry for like 10 years, but I was in the trade division. And the thing about the semiconductor industry is kind of so secretive. So much of the core information would not go out of that semiconductor industry or industry division. But with that, my observation right now is that the major trend of the measures taken by those major countries are the combination of subsidies and export control and foreign direct investment. But although the scale of the subsidy got so increased suddenly for the last like 5 or 10 years, the scope of export control and foreign direct investment seems to be a little bit constrained or restrained for most of the countries at this moment. And I would like to note one thing that so far, not many countries have imposed like import restrictions or tariffs to constrain the imports, other than the United States imposing the 301 tariffs. And maybe I can note that it seems to be not many of trade remedies have been imposed to semiconductor industry so far. I think just because currently the demands exceed the supplies, and most of the countries need the semiconductors or the semiconductor relevant equipment or materials. So I think that might be the background. And I would like to pose one example which might be illustrative of the current situation that I just briefly checked last night, is that Japan has introduced new export control with regard to semiconductor industry in 2023. But last year, fiscal year 2024, the export amount of the Japan with regard to semiconductors and semiconductor relevant manufacturing equipment would have 10% of all the export value in Japan. And for example, with regard to semiconductor manufacturing equipment, The export to the United States have, I think, around $3 billion. But in contrast, export to China is on the, about the amount of, I think, $14 billion. So it's like 4 times bigger than the export to the United States. And I think this shows the very significant necessity of continuing the exports and imports trade of the semiconductors. Basically, I think for the semiconductor relevant industries, the market of the substantial scale would be needed. And we need, the semiconductor industries usually needs the export market to keep the business with a sufficient profit. And obviously for other industries, like countless downstream industries that would use the semiconductors, the trade is necessary. So although the recent trends of tightening the trades, we can see the strong necessity of continuing trades. Thank you so much.
Thank you. Well, the example and the statistics you mentioned is very interesting because I didn't know Japan's export to China of semiconductors 4 times of that to US. I wonder what level or what class of semiconductor it is. At least I know H2 is not allowed from Taiwan to China now. That's why Jensen Huang has been complaining, because that is related to AI and robots. So thank you. And Nicholas, anything to add on this?
Thank you, PJ, for this kind introduction. And I think my best credential actually is be PJ's student. So I'm not speaking on behalf of any of the company here.
You made me look old, so please, thank you.
So it's my personal observation from the industrial perspective, because I think I saw maybe several industrial colleagues and partners here. So I just want to take this opportunity to share. I think back in the day, I think the semiconductors would be regarded as a very key component, but now I think that all the geopolitical things and all the digital revolution and the AI revolution, now I think the semiconductor really becoming a critical infrastructure of the world economics. So that means there's a strategic value from an industrial perspective. That would be is no longer just a matter of industrial capacity, not innovation ability, but it becomes to a topic and issue of national security and also the regional stability. So that we can see from the BIS perspective that actually they have several control reasons that you can name it, but I think the key one would be the national security and the regional stability. That's my first point. So I think that will affect multinational corporation a lot, because from my observation, it's not merely compliance issues, but it has to be incorporated into a business strategy and a commercial strategy, because I think we often focus on the United States trade compliance, export control tariff, but we should not forget that there's several other maybe conflicting rules or some like different rule sets that from like Japan, Europe, EU, and China, right? So as a multinational corporation, we must take care of all the jurisdictions. And so that will increase a heavy burden from the compliance standpoint and also from the corporate strategy setting perspective. So that's my second observation. And the third, I think now is easy to say there's 2 solutions. One is to diversify your business, and the second is to increase the resilience of supply chain management. But actually, those are really very difficult jobs to do. And because it's not because just that you plan something and that will happen. It will depend on your established human resources, engineering resources, your already established capital expenditures, and there are several other factors that you have to fill in and to try to figure out how you should diversify a business and how you increase the resilience of supply chain management in terms of the trade compliance. And that's my comment. Thank you.
Thank you. Well, very difficult job indeed. I think that's what, if your company or your business has anything to do with semiconductor, what Nicholas said is what you're facing now. So not only domestic regulation level, it's also multi-jurisdiction and then international law. So that leads to our second topic. So what's the regulatory framework look like now? How do we kind of understand, perceive the regulatory framework the semiconductor industry is now facing? So can we start with Isabelle again? You can tell us something about how you see this.
Let me just focus on especially what's happening in the European Union, and I would highlight two different developments there. So on the one hand, there's of course this EU Chips Act, and on the other hand, we have this interplay on between export control, FDI screening, and then FSR, foreign subsidies control. First, the EU Chips Act, a lot's been written about this. It's very much an enabling tool where the EU is trying to kind of somehow manage this semiconductor ecosystem, as I called it. The EU is trying to attract more foreign investment, create domestic capabilities in terms of having integrated production facilities, open EU foundries. Whether that's at all realistic, I will leave to Nicholas to touch upon how easy it is to create such production facilities within a relatively short period of time. Otherwise, that act is primarily there to basically kind of pool funding, and mostly the funding is to be directed a lot at research and development. And there's already been the so-called CHIPS joint undertaking that's been published. And the idea is that within Europe, you would have kind of what they call from lab to fab movement, that would become possible. There's a time frame put on that, but hardly probably is very realistic. Otherwise, the EU Chips Act is a lot about coordination between different member states, and on the other hand, between the EU and the member states. So you do see some member states are going alone, as it were, or they want to go further in their collaboration. You have something called already the Semiconductor Coalition within the European Union between 9 member states. And a lot of the focus is on just creating the workforce and get an R&D, basically. That's where a lot of the investments are going, and otherwise it's to attract basically FDI. And that brings to kind of the second development is this interplay between export control, FDI screening, and foreign subsidies regulation in the European Union. So in terms of export control, of course, because there's not that much specialization within Europe, you would think, well, where is the need to have export control? Of course, we do have certain specialized manufacturing capabilities, including in the Netherlands, and everyone is familiar with the pressure that was put on the Netherlands in order to impose export control, a pressure that was put by the US. Export control, it's not harmonized in Europe, even for dual use. There's a common list, but there's a lot of freedom for the member states to go further and impose more stricter export control measures. So that's not really a harmonized system of any sort. There have been attempts to have more coordination between the member states, but so far that's very difficult to achieve, and there's quite a lot of pushback from certain member states. Now, if, of course, for example, then the export control on these specific printing machines in the Netherlands is imposed, What does that mean for business? Well, suddenly we saw a lot of, especially Chinese companies, looking to invest in the Netherlands, whether it's through a greenfield investment or otherwise buying a factory. Because the idea would be, well, if we have an investment establishment in the Netherlands, we can buy then the manufacturing equipment in the Netherlands, we'll manufacture up to a certain stage in the Netherlands, and then we can export, including to China or other parts of the world. And on these other products, there is no export control. But that is not that straightforward to do in Europe, at least, because you have FDI screening. That's an obstacle right now. Again, this is an area where there's more and more coordination between the member states, but still there's a lot of discretion still at member state level in terms of the criteria for screening and how the procedure is run. Increasingly, we'll see that the powers are shifting to Brussels for FDI screening, but right now we're not there yet. So we do have kind of then national authorities looking into, is this actually an FDI that needs to be notified? Can we screen it of our own motion? And what objections are there in terms of national security, public order? And basically, it's a non-exhaustive list of criteria on the basis of which screening can be done. And different member states might take very different positions on this issue, despite the EU's broader interest in attracting FDI in respect of semiconductors. And then there's an additional complication for especially the Chinese companies that were trying to kind of establish, especially in the Netherlands, is then the fact that they might have been benefiting from foreign subsidies. And the foreign subsidies could also have to be notified, or they could have ex officio examinations in Europe. So what we're seeing is kind of, you could say, well, isn't this kind of, on the one hand, a certain work around the export control? It is. Is it circumvention? Probably not in a strict sense. But in any event, Europe wants to attract FDI and have actually kind of some of the technology move to Europe, have also this skilled workforce come to Europe. But there's a lot of obstacles in different sorts. And there's not a kind of centralized monitoring of how this is managed. So we have to ask ourselves, is in Europe at least, do we have the right balance in terms of the regulatory approach? And ultimately, we see that it's still a very fragmented approach because of this very delicate and difficult kind of question of competences in Europe between the European Union and the member states. And that is, of course, an obstacle that Europe has in terms of how to manage that you might not see in a lot of other countries that face the issue of semiconductors. Thank you.
Well, following your comments, I have a question. Perhaps you can answer, and Mari and Nicholas, please feel free to jump in. When we talk about the changing regulations, and as you said, the EU Chip Act, right? Do you see that as an interaction with the regulations in other countries, or reaction, or competition? You know what I am saying. I'm talking about the very active executive orders of certain country, right? So that has already changed the whole landscape. So what I'm learning is that every country now has to have its own semiconductor policy as well as legislation, and they are forced to do it, right? So do you see that happening in Europe, that it's not like standalone, you do your own semiconductor policy and legislation? Most of the time you are responding or reacting to other countries. So we used to say competition and cooperation. Now we see competition and competition. So is that happening? That's from your point of view.
Well, in Europe, this is very much seen as part of what we call now economic security. I think there is definitely, it's an angle, or the intake is very much, it's about competition. The EU has not been competitive in this area, except for one specific part of the production chain. I don't think it's really, if you look at the CHIPS Act there, it's very much interfering with the policies of other countries. It's very, as it were, inward looking for the EU to just develop this skills set and attract FDI and ensure that there's more capacities in Europe. I think it is not necessarily a problem with each country having its own semiconductor policy. I think it's more problematic to think that each country can have its own full production line in semiconductors. And it seems that some of these policies have that in mind, saying we can be fully self-sufficient here. And I think that's the point that Mario already made also, kind of we need open liberalized trade here. That's in the interest of these major trading partners. So I would definitely not compare the EU CHIPS Act as any type of executive order we're seeing at the other side of the Atlantic. And we can talk about this more also, but the EU also is kind of forming alliances in different ways with a lot of other countries. Those is often not in the sense of formal agreements, but there's all kind of MOUs, partnerships, etc. That the EU is trying to conclude in order to, in essence, signal to investors, you know, these countries, let's say the EU and India, we think alike about semiconductors, or at least we're looking in the same direction. And thus, for our respective investors, we are relatively kind of stable places to invest when it comes to semiconductors. So I think the EU, it's an inward-looking approach, but it's very much kind of has also a cooperation component.
Thank you. Mōri, what do you think? Is Japan also reacting to this very fast-changing regulatory framework in terms of not only export control, but also FDI screening, subsidies, etc.? Do you think Japan is kind of forced to do it?
You know, I think I'm in a good position to say that I do not know exactly, though I was in the government. But I think there is an element of pressure from the United States, especially for the export control, because the export control, I think the timeline is really, corresponds to the United States export control tightening. And, but on the other hand, with regard to like subsidies, I think there is no kind of, the pressure from the United States, obviously. I think it is us, I think in the EU, it is just to promote the domestic industry with, if possible, the help of the foreign investment into Japan. But that's my short answer.
Thank you. And Nicholas, you have my sympathy. Your company is caught right in between. So you have pressures from all sides. So how are you responding to that? I mean, your company or the industry?
I think that from a more micro perspective, as a corporate perspective, actually the changing trade regulatory regime really affect a lot on the industry, because to make it more simpler, I think that it would change that where you buy and sell, where you invest, where you manufacture, and also how to innovate. So that will affect a lot, because we can see from the U.S. export control perspective, actually they're just expanding the control items from the materials, components, parts, equipments, and to people, right? So this is two-way. One is that you cannot hand over the control item to the restricted persons. And the other way, you cannot bring the U.S. elements type of personnel to the restricted region. So that's two-way, and that will affect a lot when you want to invest in innovation, or you want to invest in new sites, and that will to make it more simpler, I think Isabelle mentioned about the ecosystem. So I think the ecosystem in the semiconductor business is very, very important because that it will require a very intensive human resources. It will require a very high tech and middle tech and low tech equipments and materials, and those cannot be built from just an executive order. So actually, we must plan and try to figure out what is the best way that we will not create redundancy in the supply chain management, and at the same time be compliant to the different export controls from different jurisdictions. And that's my observations.
Nicholas, can I ask you a question? In your capacity, in your job, do you have to talk to different governments privately to get a better understanding of what is the upcoming regulations, or what do those jurisdictions, those authorities expect? Do you do that very often?
I think PJ mentioned a very important point to have an effective compliance program, is that you must maintain a very amicable and very platform that you can communicate with the government officials from different key jurisdictions, including the United States. And I think some may know that actually there is a BIS of officers stationed in AIT responsible for not only Taiwan, but Japan and Korea, South Korea. And so I think that's very important that you keep communicating with the officials and share ideas. And because the rules, if you can see the rule, the original context, is really complex. And I don't think that any person that can understand 100% of the rules, because when it is applied in the real case, actually it will create a lot of nuances, and then that will have different effects. So I think one best way is to ask, because we all know this very discretionary about those administrative regulations. So we need government's feedback and maybe some advice that in order for a company to have a real effective compliance program.
Well, I think this has... Okay, go ahead. Go ahead.
I was not correct enough to say that we are just welcoming the investment, because although it is not because of the, I think, pressure from the United States, but from the internal necessity, but Japan has included the semiconductor industry in a specific core industry, which would need the approval in advance very recently. I think it was in 2023. And when I see the explanatory material published by the government, there is a specific explanation of the possible example where the investment, inward investment, will be rejected, which will be the investment would cause the leakage of the foundational information, which would be the foundational to other industries. And so I think this kind of explicit consideration of competitive elements or industrial elements was kind of indicate the significant turning point with regard to the use of foreign direct investment, inward direct investment. Thank you.
Thank you. But let me go back to Nicholas' comment. As you can see and hear from him, I think that to some extent reminds us of the uncertainty Professor Schaeffer just mentioned, right? We used to be in the world that you look at the law, the regulations, and you understand what the authorities expect or what they would require. But I think we are now in a world that you have to talk to them and keep watching what they are doing in order to understand what you will be required to do. So that's uncertainty, definitely. And next topic, we would like to move on to WTO, to FTA and BIT, more international economic law. So I'm not sure how can I ask the question. Let me start with Mōri. Can we start with you? That how do you think WTO, the FTA, BIT would impact on the semiconductor regulatory framework?
Thank you so much again. So I would like to speak from the Japan's perspective, because I'm not capable to speak of all the other governments. But in general, Japan, I think, is really trying to comply with the WTO role or FTA and BIT. I think it's a traditional standard position of Japan, basically because I think those the structure under the rule of law would ensure the stability and predictability of the business environment, which would be beneficial for Japan as a kind of middle power. But and I think I can add that Japan, I think, basically would generally see the other countries' policy change. So it tends to be do not want to go in advance, meaning to seek an alliance with other countries' policies. Like, I think, for example, all the subsidies, I think Japan has observed the other countries' movement to go on with a significant increase of subsidies. And with regard to export control and investment regulations, I think Japan has observed the other countries' movement as well. And with specific issues, for example, subsidies, I think in structuring the subsidy measures, it is, I think the initial assessment is whether Japanese government would include the condition of domestic content requirement, etc., the elements of prohibited subsidy. But with regard to that, I think all the countries are kind of fostering, promoting the domestic capacity right now. So there is no real element of export expansion yet. But so I think all the governments are careful about not introducing the domestic, local content requirement so far. But the next issue is whether it will be an actional subsidy that is would be inconsistent with the yellow subsidy rules under the WTO agreement, or to be countervailed by the other countries. But with that, I think so far, again, it is still in the stage of nurturing the domestic capacity for major countries. So with the situation of many countries are providing subsidies so far, I think it is a little bit difficult for each other to attack the other country's subsidies, because it will backlash to each own country. And I think legally, it might be a little bit difficult to establish like causal link with the subsidies, the specific subsidy, and the serious prejudice caused to other countries as well. So although there is a risk of inconsistency on the side of actionable subsidy, the risk is still kind of decent, can be. It's not a specific focus at the moment yet. And with regard to export control, I think it should be left to other topics or the other rounds, but it is a really crucial issue. And I think the export control so far with regard to semiconductors can be justified only under GATT Article 21b2. Maybe the transaction which would lead to the military establishment, which is the latter half of the B2. But I think To stick with that notion that the export control measures can be justified only under this narrowed national security, it's very important to limit the abusive use of the export control. And I think for practical reasons, as I mentioned, to keep the export market is really, really important for any semiconductors industries. So to make an excuse that we cannot expand the export control to like legacy industry, legacy semiconductors field, etc. I think this is a very good, valid legal reason to not to expand the export control to unnecessary field. And lastly, with regard to the investment, since the investment specifically, as it is not covered by the WTO agreement, it would be a matter of FTA. And as an example, CPTPP, you can notice that the security exception under CPTPP is really broad. I mean, the subparagraphs, which is under the GATT Article 21B, do not exist in the CPTPP. So this means that some kind of a new economic security consideration, which would have some industrial consideration, may be justified under the CPTPP. And that aspect might be beneficial for the countries which are reliable to each other, meaning the expanding slightly the scope of the measures that can be justified under the national security. But if it is about with regard to the relationship with non-reliable countries, there will be a huge risk of abuse of these broad national security. So I think this means that, for example, to make use of the CPTPP, I think it is necessary to limit the joining parties to a really reliable persons with regard to the foreign direct investment. Thank you.
Isabelle, can I ask you a more challenging question? Do you think WTO can carry on with what it has been doing for the past 60, 70 years? And with no major change in response to what we are facing today? Or do you think at least what we talk about today, semiconductor strategic assets, can WTO do something more to respond to it? You know what I mean, right?
It's a very multi-layered question, but I'll make an attempt. I think there's, of course, great potential in the WTO, and especially free trade agreements, to just liberalize trade in semiconductors. We always immediately talk about the justifications, national security, but the extent to which you could liberalize trade by lowering tariffs. For example, semiconductors are not included under the ITA. So there's great potential there. But of course, we mostly look at these WTO agreements, FTAs, for the justifications. And Mario already talked about that. And I do think that in the investment agreements, you have much broader security exception clauses, but you also have some agreements that have none, and that is causing a lot of difficulties, especially in the sanctions context, but also in the export control context. We could see that more visibly arising, or restrictions on FDI. In the WTO, so we have no case yet giving guidance on export control on dual-use goods. We have, of course, a lot of case law coming out of the WTO the last few years in terms of the third subparagraph. There was a dispute between Korea and Japan, DS 590, but eventually that panel was not composed, and maybe there also one consideration might have been, well, there's so many countries imposing export control. Do we really wish a WTO panel to review this and potentially set some limits? Because a lot of the countries that are imposing export control seem to want to go a bit further than what they're currently doing. So I think just like with subsidies, it's that same interest that also comes into play in thinking about what cases come to the WTO. In terms of the question of subparagraph 3 versus subparagraph 2, and without wanting to go into the scope of some of the panel discussions during the next few days, I mean, I think probably the US is probably capable of arguing that all export control and or all measures, restrictions in terms of semiconductors are subject to subparagraph 3, taken in time of an emergency in international relations. I think a lot of other countries would be quite reluctant to go that far. Of course, I think you can have, for example, in a situation of war, and you restrict all trade, including semiconductors. Of course, that could be subparagraph 3. But if we then zoom in on subparagraph 2, I mean, it raises some interesting questions because obviously that text was not drafted having in mind, you know, the situation we're having now in terms of economic security, industrial policy. Maybe to highlight 2 questions. The first thing is that perhaps it is always easier under the second subparagraph to justify subjecting certain goods under export control than to make existing export control stricter. There are 2 different types of measures, and actually in DS 590 it was the second type of measure that was at issue. It was about making the controls stricter, and export control, you can do that in many different ways. So probably the standard of review is the same, but maybe it is more harder to justify, depending on the facts, the decision to make existing checks stricter. Because the subparagraph really talks about the relationship to the trade in these particular goods. So if you then make it stricter, what is the reason for that? And the second point, or one of the other interpretive questions is, of course, where do we draw the line? And I think Mary's point also went into that direction between kind of really this military context in which subparagraph 2 was designed and the current industrial policy purposes that are being injected into export control. And it's not quite the same probably as with subparagraph 3, because you could think of a situation where, or we can ask ourselves the situation, could the measure be covered by the second subparagraph, but not by subparagraph, by B, the conditions under B? And it's not the same discussion as when talking about, I think, subparagraph 3. In terms of kind of what else is there to kind of enhance cooperation in terms of semiconductors, I mean, one of the difficulties we see right now is that when we talk about export control, there's always been a lot of cooperation between a group of countries through these soft law arrangements, including Wassenaar, where they work on these lists of products and there's some commonality in approach. But including due to the war in Ukraine, a lot of these soft law arrangements where Russia used to be participate, these fora have mostly been blocked. They're not as, they're working suboptimally. So that's not helping. And then, as I said, like there's all these soft law kind of corporations happening, and I think a lot of countries are incorporating that in their strategy. The EU is certainly doing that. I already mentioned kind of the EU-India Memorandum of Understanding on Semiconductors, even in a situation where there's no free trade agreement between those 2 partners. The EU has a free trade agreement with Singapore, but still it's building on that with other kind of agreements, non-binding, on digital trade and semiconductors. So there is a lot of cooperation in different ways happening. I think that's mostly in order to attract the FDI, as Mary also underscored. But it seems a lot of these discussions are mostly not happening, or forms of cooperation in Geneva.
Thank you. In the interest of time, I think we should move on to our last topic about national security and the geopolitical uncertainty. Can I start with Nicholas? How do your corporation overall Or overall, what is your observation of corporations responding to these uncertainties?
Thank you. I think there's a export compliance manual published by BIS, and that might be one of the reference that we started the compliance program. And I think the recent development, from what I know, the BIS attitude actually is the so-called catch-all policy on all the supply chain, which means that it's not only you have to know your customers, but you have to know your customers' customers. And that will create a difficulty for most of the companies, such as Foxconn, I believe probably TSMC, because we are in a role, I always describe it as a sandwich, and we are in the role of the middle. And so we have a very powerful supplier of all the control items. We also have very powerful clients that are under subject to the regulations, right? So in that situation, actually, most of the time, we are not the direct exporter, and we are more at the role of the re-exporter or the transferer. And so we need, so that will come down to a very useful principle is to is in the setting I suggest is to presumption of non-compliance. So whenever that we are facing, there is a risk of export control, and we will adopt this presumption, which means that we have to deploy resources, we have to do a analysis. This analysis is not only from the legal, but also from the R&D, the procurement, the customs, and the IT, etc. So this is really a joint effort within a corporate setting that we to make sure that we comply and we adopt this presumption of non-compliance. And also, in addition to that, we also need to adopt collaboration models with our suppliers, with the distributor of suppliers, with our intermediary suppliers, such as the module suppliers, equipment suppliers, and also our clients and customers. So that represents the whole supply chains and represent all the channel business. And so in that regard, I think that we really create a lot of hard works for internally for the compliance program.
Isabelle and Mōri, do you have any comments on national security and other geopolitical uncertainty, just briefly?
Thank you so much. I made some comments about the national security already, so just about the geopolitical uncertainty, and Mr. Wu kindly suggested to talk about the recent negotiation between Japan and the United States, and I would like to make a brief comment about that. It's that, it is disclosed that Japan will be imposed reciprocal additional tariff, and the negotiation process is so confidential, and we cannot access any details of the negotiation. But I can read from the news reports that would indicate some of the elements of the negotiation. And it was hinted that Japan, with regard to semiconductors, Japan has suggested to provide some assistance with regard components and I think some manufacturing equipment, but it seems it was not enough. And it seems that the United States has suggested that Japanese industries should make more investment to semiconductor industries in the United States, but it did not work. It is so far that I have seen. And I think it shows that Japan is so willing to collaborate with United States, and maybe China and other countries. But since it is a critical phase of promoting the domestic industries with the subsidy, I think there is no room to invest additionally to the very advanced technology or the very, strategic part of the Japanese semiconductors to other countries. And so with the geopolitical risks, I think it is generally common to many countries, but each country wants to keep the strategic superiority to some extent, although it is not possible to include all the semiconductor relevant industries within one country, but each country wants to keep a specific strategic superioritized part of the industries. For example, I think for Japan it is some manufacturing equipment, because it would be a defensive tool for any coercive action by the other countries as well. So that is my current observation.
Thank you. Although, with all your disclaimer, you still touch upon a very sensitive issue, that is the link between investment in U.S. and the tariffs. I would not go there, because that's something going to happen soon. Okay, now we are open for Q&A. So, yes, quick hand there.
Thank you very much. Do you want me to from University. Sorry, thank you very much.
No, it's not working, so perhaps try the...
Hey, yes, okay. So my apologies, now it's working. So this is Pınar with Istanbul Big University. I'm the WTO chairholder. Very interesting panelist. I thank all of you, but my question will go to Isabelle. And the question, many of you thought about the FDI screening, but towards inwards investment screening. And I would be wondering about Isabelle's reaction to outbound investment screening for ASML, the Dutch semiconductor company. I was just checking the news that it seems ASML now has invested quite a bit in Taiwan within a joint venture with another company. So how is the EU looking at the outbound investment screening in this very critical matter? We understand we all are trying to comply with the US, screening metals. But, it would be interesting to know, why is the EU allowing ASML to invest in the United States and invest in Taiwan for such an important matter? Thank you very much.
Thank you. So, Isabelle?
I think there's a few, maybe a few explanations. So the first thing is that as such a separate outward FDI screening mechanism, we have none. And there's actually very few countries that have functioning outward FDI screening. Taiwan is actually a very good example. It does have outward FDI screening towards China that operates, but that's then towards a specific country. So we have none of that. And that's primarily because it's so difficult to control capital and the movement of capital. You have that in the EU for a long time. There's very few actually restrictions or regulations of that because it's difficult to regulate. There was a moment at which the Commission President announced and promised also to the US that there would be such outward FDI screening, but that's proven much harder to put in practice, although it's part of this economic security strategy. Of course, for a lot of issues you want to address sometimes under outward FDI screening, if you're not trying to target the capital, and it would be hard to justify that for just one company in one particular sector, is that you could do a lot under export control, and that is happening. So you do have technology, research, personnel, as Nicholas said, that can all fall under export control. And there are restrictions in that sense that are being applied at member state level, that you might need to get licenses for some of this, depending on whether or not then the technology, etc., falls within the lists that are being used or catch-all control, as Nicholas mentioned. So there are opportunities to check, but is it really kind of I think there are other competing interests also, and it's the same kind of maybe challenge that Taiwan has currently also, where there's a lot of pressures for Taiwanese companies to invest abroad, and there are already some commitments that have been made, including in the US. But therefore, Taiwan probably it's a difficult balance to reach. And then for Taiwan, I think there's a separate concern that here, of course, semiconductors still has a different meanings, and it has a very strategic meaning because of its semiconductor industry here, Taiwan has leverage. And if you actually move a lot of your production know-how, your skill force abroad as part of the FDI, Taiwan would be losing that leverage, and that's a very specific dimension. But I would say there are possibilities of checks, and I don't know what checks, for example, the Dutch government is really imposing there in terms of know-how technology. It can do some monitoring. And to be clear, also, export control is not always about, yes or no. It's not black and white. Yes, if it's completely for civil use, yes, but what you're often doing is allowing the export under export control. Export control is not necessarily about blocking, but you are monitoring, basically. You are asking information, you're asking companies to do the due diligence, and you want to be able to track. And that's where cooperation between countries would be so important, because if you'd know at least that different countries are doing imposing a minimum level of export control in the semiconductor industry, you would have these trusted partners that actually there we can allow the export to take place, including of know-how, because we know that, for example, Taiwan or Australia is imposing a similar minimum level of checks. So that's how this whole system is built, and that's why the breakdown of that cooperation of soft law collaboration also can have a very restrictive effect, with maybe checks being imposed where they're not necessarily due, and that then creates an unnecessary burden on trade in semiconductors.
I think I have to take the question from that gentleman because he's been holding up his hand for a long time. Right? Go ahead. And Mark, you will be the next one. Okay, thank you.
Seojin Kang from Kim and Chang in South Korea. I want to make a brief comment as well as a short question to the speakers. First of all, we seem to consider that building semiconductor supply chain without China is now the new reality in this particular roundtable. But in reality, Taiwan, Japan, Korea all have China as the biggest market of the semiconductors, as well as semiconductor equipment, as well as the materials and so on. And all three countries heavily rely on China in terms of the rare earths and other materials. So and at the same time, we now have a looming threat of Section 232 on semiconductors and the derivative products by the U.S. And I think that it's time to consider how we should optimize the supply chain against the two threats from both China and China's rising self-sufficiency and the U.S.'s tariff threats, and in this sense, I wonder what you think about the role of the CPTPP or the CPTPP plus EU in terms of the such supply chain management, and also I wonder I wonder whether keeping the so-called open global supply chain, like it existed a decade ago, like EU is specializing in the EUV equipment, while Korea and Taiwan or specialize in the logic ICs and memory chips, and China would be happy with the less than would be the legacy making legacy chips. So that's my questions and comments.
All right, you would like to hear from the speakers, right? So who would like to go first? Mōri, perhaps. You mentioned CPTPP. So.
Yeah, I would like to try to keep it short, but I think I have made some comments about the necessity of keeping trades to keep the businesses' profit, to invest in the new technology, etc. There is a strong necessity to keep the trade as much as possible. But at the same time, I think the depth of the linkage might be different between the allied countries or the non-allied countries. And with the allied countries, maybe there is more collaboration of advanced areas, but maybe not for the non-allied countries. So that kind of a gradation of the ties might more often to be seen. And even among the allied countries, I think every country needs to keep its advantageous aspect of the industries. So, for example, the rumor between the Japanese and United States negotiation, that I think there must have been a sensitive part that Japan cannot collaborate with the investment into the United States. And with regard to CPTPP, I think so as a model for the new collaboration between the allied countries, I think the CPTPP or CPTPP Plus would be very important. Maybe especially for the investment aspect, because there is no specific rule under the WTO. And as I mentioned, how to capture the economic national security exception for the foreign direct investment might be, I think, the CPTPP can make some kind of de facto standard with regard to that. And even for the export restriction, I think those fora of CPTPP that can have the allied countries together to discuss on what would be the desirable standard would be really important from now on. Thank you.
All right. Really, the last question? Mark, would you like to do it?
Thank you. I'll try to keep my question short. I sensed a bit of tension amongst the panelists about what elements of subparagraph 2 should be analyzed by a panel as opposed to all of this being self-judging. Because you mentioned that countries need to have scale, countries need to apply choke point technologies on a non-MFN basis, and so therefore they have to rely upon some Article 21 exception, and the current jurisprudence suggests they cannot rely upon subparagraph 3. So that means all of the work is getting pushed into subparagraph 2, and I just want to ask the panelists, what element of that do you believe a panel to be competent to analyze, given, as you've hinted, semiconductor companies are very unlikely to release this information to governments, so there's unlikely to be any information before panelists to allow panelists to make an adequate discussion of whether a measure is taken in a necessity basis. And we know most of these chips or rare earth materials or whatever are, the majority of which are not being designed to supply the military, but for scale purposes, you have to put this in place. So none of these measures are being done exclusively for military type purpose. So does this mean this paragraph is entirely self-judging? And if not, why not? And what element do you believe a panel to be competent to analyze?
Well, it sounds like a very good question for thesis, but I will give you Isabelle.
the 2-minute thesis then. I think, first of all, we have to distinguish between burden of proof and standard of review. The standard of review, I would say, yes, a panel can review whether a measure is taken, it relates to the categories or the traffic that is described in the subparagraph. In terms of the facts you would have to adduce for that purpose, that wouldn't actually be that difficult because you don't need the facts of a specific case, at least in respect of putting the product under export control. In terms of then the broader paragraph B, the broader standard, let's just assume we accept the plausibility test in terms of the standard of review. There, I think it gets a bit more difficult when actually, and that was my point, if you make the existing export controls stricter. Yeah? Because then you will have to potentially provide some evidence in support of the plausibility test that is no longer about whether the measure relates to the product, because that's already covered, that's already been established. So that's what I think is more difficult. But of course, when we talk about dual use, it's just something to take into account is the nature of it is always, of export control of dual use, that trade in civil use of the product, so that you don't want to block, is the collateral damage of the fact that you want to monitor and potentially restrict the trade in the goods if they are put to military use. And that makes it quite tricky because there's like two sides of the coin, and that's something that the drafters didn't really make clear in negotiating the text. So there's some interpretive discussion that you can have about dual use, but ultimately I think a WTO panel, as a matter of principle, would allow that export control on dual use goods can take place. What for me is more difficult is then, and for many of these products, especially for dual use, for semiconductors, whether you're thinking of the products that were at issue at DS590, you can actually, some of these products do have links to some of these soft law cooperation mechanisms on dual use, and you can make the case that they can be put to military use in certain instances. And most of the decisions would be about subjecting the products to export control or making the rules stricter. A separate question if it's then an individual measure in respect of an individual company.
That's the nature of my question when it's being applied in an individual basis on a non-MFN basis, not the measure as a whole, but the applied measure.
Well, I think that a WTO member might be can review it, as I just outlined, and might be kind of quite reluctant to go then in the individual facts of a specific case. So, but they would, if they would be happy with the idea about the general applicable framework in terms of the level of export control scrutiny that applies, that there would be quite some reluctance to look then at the very individual circumstances of the case. And that's just based also on the case law we have now under Article 21, where on the facts you don't need to show that much in order to win a case under Article 21 as a defendant.
Thank you. You're welcome to continue the topic in lunch. Sorry, we're... Something to add?
Just to clarify my comment, I do not think that God Article 21b2 should be interpreted in a loose manner, meaning that those considerations should include the industrial policy. And so I think with regard to God Article 20b2, it should be strictly interpreted to limit the use of export control for the transaction that would be relevant to the military use in some extent, like whether it would be it would have a possibility or probability to reach to the military establishment, etc. Those kind of elements would be needed. But with regard to, I think, CPTP type of security exception. There is only the notion of the protection of its own essential security interests. So there is no limitation of the subparagraphs. And I think there may be a possibility to discuss some kind of expansion of the concept of national security exception, because I think most of the countries kind of agreed on a necessity to keep the strategic, what's the industries on its own. Thank you.
Thank you. With that, I happily announce that we conclude this roundtable. Thank you to those distinguished speakers. Thank you.
Thank you once again to the moderator and the speakers for an amazing round and Q&A session. The first roundtable discussion is now concluded. It is time to take a break for lunch. Please be reminded that no food or drink is allowed inside the conference hall. Meals will be served by our staff on the 4th floor of this building, and guests can have lunch in rooms 1402, 1403, and 1302 of this building. The panel session will begin at 2 p.m. Thank you. 第一场次已圆满结束，接下来为午餐时间。 请注意，会议室内禁止饮食，请至本会场4楼，现场将有工作人员发放餐盒。1402、1403以及1303教室可开放用餐。下一场次将在下午2点开始，谢谢大家。